Today on Don't Talk TV, I want to talk a little bit about two very important cases that are being fought by the Justice Center for Constitutional Freedoms. One that seeks to have the COVID quarantine hotels suspended, and the other fighting the imprisonment and fining of Pastor Coates in Calgary, Alberta, and the other fighting the charges against Pastor James Coates of Grace Life Church in Stony Plain, Alberta. Hello, my name is Nicholas Wansbutter. I'm a criminal defense lawyer in Stratford, Ontario, Canada, and welcome to Don't Talk TV. So as I mentioned in the preamble, today is another episode where I'm discussing things to do with COVID, and I certainly don't intend Don't Talk TV to be the COVID channel, or the lawyer talking about COVID stuff channel. It's something I feel as a lawyer I have to talk about because of the unprecedented attacks on our most basic freedoms that are happening every day. I certainly never thought I would ever see a day in Canada where churches would be forcibly closed with their locks being changed. People would be arrested or at least fined for the most basic things such as seeing a family member or having some contact with another human being. These things are being accepted by many as an end that justifies the means. And I hear people frequently saying, well, we just need to be patient, but we're now in year 2 of this, and it seems that things continue to ramp up more and more. My wife was raised under communism in Poland. Her family fled their homeland and defected to Canada in 1986. She was just a child at that time, but just the other day we were talking about her memories of growing up under communism, and as a child, what did she remember? And she remembers seeing soldiers outside stores, there being limitations on where people could go and when, and specifically restrictions on religious gatherings. She, along with other people from former communist countries that I know, are the ones who are the most concerned about this because they've seen this before. So as I mentioned, there's two cases among many being argued by the Justice Center for Constitutional Freedoms that I want to talk about. The first being their constitutional challenge of the requirement that Canadian citizens returning to Canada after a trip outside the country being required to be quarantined in so-called COVID hotels. Essentially, these are hotels where they're forced to pay a very large amount to be confined within a hotel for at least 3 days while they wait for a COVID test to come back. And as I mentioned in a previous episode, there have been allegations of sexual assaults happening in these places, allegations of very substandard food, if any food on occasions. Certainly a very difficult situation. And a viewer of Don't Talk TV had heard about this challenge and the fact that the Justice Center had filed for an injunction, which would be a temporary order while waiting for trial, putting a stop to the COVID-19 hotels. So I want to take a look at the court decision on that. So just last week on April the 23rd, 2021, Mr. Justice Pentney of the federal court made a ruling on this application for an injunction. So just to be clear, this is a ruling only on the injunction waiting for trial. The trial is still going to happen. The judge gives a summary of his ruling at paragraph 7 and following. So he says, for the reason explained below, this application for an interlocutory injunction will be dismissed. And the reasons for him dismissing that are, among others, any harm to the applicant's rights and freedoms from a temporary stay at a hotel is not a sufficient basis to suspend significant public health measures that is based on the advice of scientific experts and seeks to prevent or slow the spread of COVID-19 and its variants into Canada. So I know some people who'd been the person who asked me about this, they had heard that the injunction had actually been granted. It hasn't been granted, but the case is certainly far from over, although that first little preamble that I quoted from the judge sounds like he certainly doesn't have a lot of sympathy. When we look at the decision, there are actually some positives in here, and I think it's important to consider that there's quite a high test required for an applicant to meet in order to get an interlocutory injunction. So paragraph 52, the court talks about the test, indicating that there are certain special considerations that apply in cases like this one where the claimants seek to suspend the operation of legal measures adopted pursuant to a statute. The careful balancing process that must be undertaken in a case such as this was described by the Supreme Court of Canada in R.J.R. MacDonald Incorporated versus Canada. So they indicated here that on the one hand, courts must be sensitive to and cautious of making rulings which deprive legislation enacted by elected officials of its effect, but on the other hand, charges the courts with the responsibility of safeguarding fundamental rights. For the courts to insist rigidly that all legislation must be enforced to the letter until the moment that it is struck down is unconstitutional might, in some circumstances, condone the most blatant violation of charter rights. The court goes on to note that considering that we're at the early stages of litigation, this is at paragraph 59, the fact that the underlying application will soon come for a full hearing where the charter issues can be fully presented and considered, and the fact that the court found that at least one of the applicant's arguments is worthy of further consideration, it is not an appropriate case to dismiss the application solely on the basis that they have not made out a sufficiently strong case on the merits. So this is the judge suggesting that there is some merit to the case, and this is worthy of going to trial. So he's not refusing the injunction on the basis that it's a weak case, it'll never succeed, and he's prejudging. He's suggesting that there is something legitimately to be argued here. And I think it's also important that at paragraph 124 here, the judge said, "I accept without reserve the applicant's reminder that in a time of emergency, the role of an independent judiciary in safeguarding the rights and freedoms guaranteed to Canadians by the Charter takes on additional importance. History demonstrates why the bulwark of the robust protection of charter rights by an independent judiciary is so important in times of crisis." The court goes on to say that it must be recognized that this pandemic is a type of situation that can inspire irrational fears and passions, which may in turn provoke a government to adopt excessive measures that trench unduly on the rights and freedoms of individuals. It is necessary, therefore, to subject government rationale for any emergency measures to a degree of scrutiny that is proportional to the risk that charter rights may have been impaired by actions based on irrational fears rather than the careful weighing of competing interests based on the evidence. So those are some good comments from the judge. Again, this case is very early in its stages, so as of right now, the COVID hotels are still in effect. They have not been struck down, but the trial is coming up quickly. I believe this case is to be heard in early June, so the charter will be fully argued at that time, and evidence will have to be called by the Crown in order to support those orders. So this brings me to the other case, that of Pastor James Coates, which will be proceeding in Edmonton, and that started on May the 3rd. Now, this is too recent for there to be any published judgments out, so I'm just looking at the Justice Center website. And a couple points of note here. The trial will proceed for up to 4 days initially, but will then be adjourned because government lawyers are not yet prepared to present any medical or scientific evidence that might support the health orders under which Pastor Coates is charged. Now, this is quite astonishing that we're about 15 months into this and prosecutors are not able to marshal medical evidence yet and need an adjournment. It certainly brings one to question what will they be able to present, because in a court of law such as this, where a charter challenge has been filed against the lawfulness of these orders, the Crown Attorney will have to present real hard medical evidence to justify these infringements on the Charter of Rights and Freedoms. It will not be a situation where mainstream media reporters who are unabashedly in favor of lockdowns are lobbing softball questions to people like Dr. Dina Hinshaw. This is a situation where she will be cross-examined vigorously by experienced counsel, and where evidence, firm, solid evidence will have to be presented to the court. And that's why this case is very important, because it could have ramifications across the whole country. But if after 15 months the Crown doesn't have evidence, that may be somewhat telling. Time will tell whether they're able to actually bring evidence and how this goes. Another point of interest is that it says here that Judge Robert Shagech decided that up to 1,000 people will be permitted to attend the trial virtually through the court's virtual software. However, the court has decided that those people will only be able to hear the trial and not be able to watch it. There will be no video feed. The judge's decision follows the request by the government prosecution lawyer that the trial not be viewable virtually. The prosecution lawyer did not want any images or video stream of her to be viewable during the trial. The judge additionally granted the prosecutor's request that her name not be used during the trial. Now this also is quite extraordinary, and as a former prosecutor myself, I certainly never asked to remain anonymous. I can't think of any case where any of my colleagues ever requested to remain anonymous, and we prosecuted organized crime, people accused of murder, people accused of hate crimes. So it's quite exceptional for a prosecutor to be taking this position. From the Justice Center's press release, I don't know whether she received specific and credible threats to her safety. It seems a bit extraordinary to be suggesting that a bunch of Christians who just wanted to worship at their church are going to be making death threats against her, but I don't know. I would say that if anyone has made threats against her, shame on them, and they should be prosecuted. But I would say shame on the prosecutor if she's making that application in the absence of any credible and direct threats. This is something, along with the limitation of how people are able to access this trial, this is something that cuts to the heart of one of the principles of rule of law that I spoke with in last week's episode, that the trials be public and that justice be public. This isn't a completely secret trial. The rulings will ultimately be published and 1,000 people will be able to at least listen, but they are making it more private and more secret than the average trial. Although granted, pre-COVID, you wouldn't be able to fit 1,000 people into the average courtroom. So in one respect, more people are able to have access to this trial than would normally be possible. But on the other hand, we're limiting the video and hiding who the prosecutors are. So it'll be very interesting to see how both of these cases turn out. I will certainly be following them closely, and I would suggest that individuals who are concerned about the state of the Charter of Rights and Freedoms in Canada, the state of our country and our freedoms, should pay close attention to these cases as well. This video is not legal advice. If you have a situation where you need legal advice, please contact a lawyer. You can call another lawyer or myself. My 1-855 number is listed below, and we can give you advice that's tailored specifically to your situation. If there's any topics that you'd like to see me cover, please leave a comment in the comments section below, or send me a message over Facebook or Twitter or email. If you found this video helpful or informative, please consider liking, sharing, and subscribing, and following me on Facebook and Twitter.